What is the judicial pretrial process in a criminal case? So when you're charged with a criminal charge, obviously there's a first court appearance. You hopefully retain a lawyer. That lawyer is going to order all of the evidence. It's called disclosure, and that lawyer is going to receive that disclosure and review it. There may be missing disclosure as well. But once he or she has initial disclosure, they're going to review it with you, get your version of events, figure out whether it's heading to trial maybe, or you're looking to resolve, or you're on the fence for this. But once you have sufficient disclosure, then the Crown's going to meet with the defense counsel. They're going to talk about whether the case is resolving, negotiated deals, whether it's heading to trial. So you have all these discussions back and forth, both getting instructions to your client, talking to the Crown, and moving the case forward slowly. And you have various court appearances. Now, at some point, you're going to have sufficient disclosure in your hands and after meetings with the Crown as well and your client, to conduct what's called a judicial pretrial. This is often required in many cases. Now, what is a judicial pretrial, first of all? Well, it's a fancy word for a closed-door meeting with a judge, who's not the trial judge, by the way, the Crown attorney, and defense counsel. And they're discussing all aspects of the case. For example, they discuss a resolution deal. Let's say the Crown and defense are agreeing to a 90-day sentence. You're seeking approval from the judge. You're going to fulsomely discuss the accused's background and why the plea deal is taking place. On the other hand, you're also discussing trial issues. If the matter's tending to head to trial, you're talking about management of trial time, what motions need to be brought, pretrial motions or applications, witnesses are going to be called, all of the legal issues. So it's a very fulsome discussion, and we're exploring avenues whether the case can be resolved, even dropped or withdrawn, or heading to trial. So you're talking about both management of court time, management of court resources, and attempting to resolve the case if your client wants to go that way. And there's all sorts of things that can be discussed at the judicial pretrial. The judge is not the trial judge, so they can make you can openly discuss the case with them in many instances, not necessarily revealing all your defenses, but in some cases, if you've got a strong argument, you may want to reveal it if the Crown can't fix the argument. And sometimes pretrial judges will push the sides to mediation or push the Crown to drop the charge on a particular case. But it's all about managing court time, resources, seeing if we can reach a resolution that's approved by the judge if your client wants to go that way. So it's not a meeting that the client attends to. And though pretrials can take, 10, 15 minutes up to, I've been at them for an hour and a half. It just depends on the case and how complicated it is. But it's a very helpful for both defense counsel and Crown to assess their case, because you're getting input from a third party. Sometimes the judge will knock the Crown's head a bit and say, look, you've got a weak case, you should withdraw that. So I often will have judicial pretrials even when it's not required. When you're heading to trial, it's absolutely required. You have to have a judicial pretrial. And in the Ontario Court of Justice, that's the lower court level. If it's a case you have an elected, more serious case where you've elected by the Superior Court of Justice, sometimes paperwork's required to be filed, sometimes not. It depends on the case. It depends on the county. If you're in the Superior Court of Justice, for example, on a more serious charge, and you've elected Superior Court, they have particular forms. They have a lengthy 20, 30-page report that you've got to fill out all aspects of the case for the judge. The elections, the pretrial motions, what applications are taking place before the trial, all the trial issues, witnesses are going to be called, because it's very important that we properly estimate whether a trial is going to take 2 days or 2 months. Every case is different. And those can be very complicated. Some cases are very complicated. And again, it's the same procedure in SCJ, except there's a more complicated form to fill out, I guess. But all of these things are with a view of, as a defense counsel, you're trying to get the best result for your client. You're hoping the judge might put some pressure on the Crown if they have a weak case to withdraw it. And you're hoping the judge will give some input if the Crown's and you are disagreeing with evidentiary issues or background issues, that, hey, you're wrong about that, Crown. You should back off of that. And the Crown doesn't, believe it or not, have to listen to the judge if they disagree, but often there's going to be pressure on the Crown by certain people. So there you have it. That's a judicial pretrial. It's a required step before you set a trial date. It's often a step you want to take to get a deal proved. Let's say you have a joint submission. for resolution. Your client wants to plead guilty. And as an example, let's say it's a assault bodily harm and it's a 6-month joint submission for jail. So you're both agreeing that, but you want to get approval of the judge because the reason the Crown went low is they had a slightly weaker case where they might lose, but you wanted to settle it too because you might lose and face 5 years. And the judge can approve it then, and you can go in front of that judge and do the deal with full satisfaction that he's going to approve it. It's no fun if you don't have a judicial pretrial and you wind up in some judge who finds the deal is egregious and against the administration of justice. You'd agreed on a 6-month sentence with the Crown, and the judge is throwing your client in jail for 3 years. So that's another reason to have a judicial pretrial. So it's very important. It's an important process. It's a step before setting a trial date. It's often a step you take to get a deal approved. It's often a step you hope to get the right pretrial judge maybe to bang your heads together a bit, especially the Crown if you're defense counsel, to convince them to take certain steps that they're not currently agreeing to, and especially on weaker cases, because you will run into Crowns. Maybe they're not experienced, maybe they're very difficult Crowns. They might be forcing a case forward that you don't think should be going forward. And I know some judges will sit there and say, look, you've got a weak case. You really want to waste our time, our court resources on a 5-day trial with a weak case? And your client still has risk on a weak case because you could lose. So it's nice. I often have judicial pretrials even when I don't need to, but it's definitely a required step if you're setting a date for trial. After the judicial pretrial is completed, by the way, sometimes you require more than one. I've had 2, 3, 4 judicial pretrials on complicated cases. But after the judicial pretrial process is completed, you're now in a position to either A, set the court date for a guilty plea, or B, set the date for a trial. So that's, in a nutshell, a simple version of the judicial pretrial process in Canada. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.